Do you know who is the third largest landowner in India after the Indian Railways and the defense? It's the Waqf Board, which controls over 8 lakh properties with an estimated value of 1.2 lakh crore rupees. The Waqf Board is a Muslim organization that controls the property that is donated for pious, religious, or charitable purposes in Muslim law. The BJP is proposing almost 40 amendments in the Waqf Act. This has led to a huge outcry, with many saying that this move is part of BJP's Hindutva agenda and they are trying to limit the Waqf Board's powers, while others say that it is a progressive step that has been pending for years. So, to talk to us on this topic, we have Supreme Court lawyer Nipun Saxena. Watch more to find out. One thing that one section, especially in this act, that has been the talk of the town, that has been quite controversial, is Section 40 of the act, where a lot of people are coming out and saying that this section actually allows the Waqf Board to proclaim any land in the country of India as its own. So, could you tell me your opinion about that? Does it actually allow that? Is that true or not? Could you just explain?
So you see, it's very interesting because the subclause one itself of that particular provision goes something like it that the board may itself collect information, which is it may on its own collect an information regarding any property which it has reason to believe to be a waqf property. And if any question arises whether a particular property is in fact waqf or not, or whether what kind of waqf it is, whether it's a Sunni waqf or a Shia waqf, right? It may, after making such inquiry as it may deem fit, decide the question. So the first point of criticism is that how can a waqf itself decide it wants, whether it could deem in its own wisdom that it's a waqf property or not, right? But if somebody looks at Section 40, it has to be looked, you see, in conjunction with Section 5 and 6 of the Act, right? Because what happens is that there has to be something called a preliminary survey of Waqf. Waqf is the property, which is the subject matter of dedication, right? Preliminary survey has to be done. Every state government is supposed to maintain a list, right? If there is a new, property, then in respect of that, the survey commissioner will have to make inquiry, right? Before it decides or before it, the things move to the next process, right? And if at any point of time there is a dispute, let's say somebody says that, look, you have taken away my property wrongfully. It was never included part of Waqf, but you, the board, in your wisdom, decided that this was a Waqf property when it was not, right? So, in case of wrongful inclusion, or let's say somebody says my property was Waqf property, but you did not decide it to be so, right? So, in cases of both in exclusion as well as wrongful inclusion, a person gets a right to institute a suit under Section 6, because whatever Waqf board says is not final and operative. There's also a tribunal, which is a court, which has been instituted under Section 83 of the Act itself, which further gives power to the tribunal to decide whether the decision of the Waqf board is proper, right, wrong, good in law, bad in law, right? So while the critics may have a point when they say that, look, the Waqf board itself gets to decide everything, it is not that the Waqf board's decision is final and binding, because the same can be challenged before the tribunal. Of course, one has to make a challenge to the tribunal in case a wrong inclusion exists or somebody's property is omitted to be included, right? Because subsection 2 categorically says that unless and until it is revoked or modified, that order of the board which was modified by the tribunal, it becomes final and binding.